Let's analyze an example of having 6 questions on the exam, out of which you will be required to answer 3. If that's the case, you can study 4 main topics that you understand the most. You should select the 4 topics that you like, that you think that you will be able to provide the best answer. In company law, the 4 main topics are corporate personality and bail, constitution and altering, and directors' duties and insolvency. Those 4 topics is most likely going to come up on your exam. So it would be a very good practice that if you answer problem and essay style questions on these topics. How do you answer a problem question? Firstly, you need to identify all the legal issues in the question. And if you are able to identify at least 80% of all the legal issues that arises in the problem question, it's most likely that you will get a high grade. However, identifying the legal issues is not the only thing that you need to do. You have to apply the correct law and provide the right analysis. The analysis part is the hardest. That's where students lose most of the mark. If you focus too much on explanation of the applicable law, your answer will become explanatory and you will lose marks. So make sure that there is both rule and application part. Once you discuss the applicable law, you have to apply it to the facts of the case, make an argument, and provide a conclusion of what would be the most likely outcome if this case went to the court. Essay question style is a bit different. However, making arguments part and analysis part is similar. Here, similarly to the problem question, you have to identify the issue that you are going to discuss. However, unlike to the problem question, here you don't have specific facts you have to discuss. You just have a question that you have to analyze. So we still have to identify the correct law, but we're not as much limited as we are in problem question. So once you identify the correct law to be discussed for your essay question, you have to refer back to the question and make an argument. Making an argument is the hardest part that in the essay question. Most of the students lose marks here, so be careful. Make sure that all the laws that you discuss actually answers the question, because most of the students just when they hear an essay question, for example, about corporate veil, they see corporate veil in the question and they think that they have to write everything they know about corporate veil. But that's not how you answer an essay question. You have to answer the specific question that has been asked to you. So make sure that all the arguments you make in the essay answers the question asked, not discusses everything you know about the topic asked, but answers the specific question. The best practice would be if you go to our website and have a look at our model essays, and there you will understand better what is exactly expected from you in essay style questions. Corporate personality and bail. You can read our notes on this topic here, but this is what it is actually, this principle. The corporate personality principle, it means that company is a separate person from its owners. You can have a company, right? But that doesn't mean that you are the company. The company is a separate person. Company is both association of its members and a person separate from its members. So it's quite a unique creature, it can be said. The key case that you need to know about corporate personality and where it all started is Salomon case. In this case, Lord McNaughton said that the company is at law a different person altogether from the subscribers to the memorandum. And it may be that after the incorporation, the business is precisely the same as it was before, and the same persons are managers, but it's still not the same person. company is a different person than its owners. Nor are the subscribers and members liable. In other words, if you have a limited liability company and the company does something, you're not personally liable for it. The company is. That's the whole idea of limited liability company. If a company has a loan, you are not personally liable for it. However, there are cases when corporate veil can be lifted, but we will discuss that later. Now we can talk a little bit about the Salman case, because it's a very, very important case. And if you will most likely going to get a question on this in your exam. And it's very, very important that you know this case and what happened and what was the judgment exactly. So here, basically what happened is that Mr. Salman was a self-employed person, and he had a business as a self-employed person, and then he created a company instead. He created a company where everyone in the company were his family members. It was his wife, his children. So there were 7 owners of the company, 7 shareholders of the company, and everyone was Mr. Salman's relative. After what happened, the issue in this case was that company went into liquidation, and Mr. Salman was a preferred creditor, and basically the company had loans, and the creditors wanted to make Mr. Salman personally liable, because after paying off Mr. Salman's loan, there wouldn't have been any money left for the creditors, and the creditors wanted to recover the money that the company owed to them. So they said they wanted to interpret the separate personal liability of the company alternatively. In other words, they just wanted to make Mr. Salman personally liable for the debts. In the first judgment, it was argued that company had conducted the business as agent for Mr. Salman, so that he was responsible for all the debts in court in the course of agency for him. So he was recognized as an agent. However, on the appeal, it was argued that Mr. Salman was not personally liable for the debts, because the whole idea of a company being a separate person from its members means that the member of the company cannot be made personally liable. However, there are cases when corporate veil can be lifted. This basically means that this protection that a company offers to its members can be disregarded by the court, so that they can find out what happened exactly and compensate the party injured. In this case, lifting the corporate veil is mainly cases about fraudulent activities. If members of the companies are involved in some fraudulent activities and they are basically trying to steal money from their creditors, and they are relying on this protection that a company offers in order to get away with their fraudulent activities. In only that kind of case, a court may be prepared to ignore the protection that company offers to its members, look behind the veil, see who are the members, and investigate their activities and make them personally liable. The main case is Priest versus Petrodol. So in this case, Lord Sumption and Lady Hale explained this doctrine of piercing the corporate veil in more detail, and they identified the specific circumstances in which the court may pierce the corporate veil. In particular, Lord Sumption argued that corporate veil can only be pierced in exceptional circumstances, such as concealing or evading liability. So if the members of the company, the shareholders, are trying to conceal their illegal activities behind this protection, behind this shield that the company offers. Also, Lady Hill said that the first thing the courts will do in these kind of cases is have a look at any other legal alternative, legal remedies that there may exist, and only then have a look at piercing the corporate veil, because it has to be the last resort. Why? Because the whole idea of the company is that the company is a protection for its members. And if this principle is compromised, then it will be very bad for the business. So English law doesn't want to make, doesn't want to liberate the law, to make the law very liberal about this, this area. Example essay question. Very often this topic comes as an essay question, and this can be the kind of question that you get on this topic. The judgment by the Supreme Court and the judicial reasoning provided in Priest versus Petrotto has been contentious and bewildering. You have to examine and critically analyze the importance of this case. So what it means, what you have to do in this case is that you have to analyze for and against the statement, make arguments around this statement, which means a critical analysis. But in no matter of form, you have to write everything you know about this case and everything you know about lifting the corporate veil. Example of the analysis would be the following. Lord Sumption made it clear that claimants must search for alternatives rather than piercing the corporate veil. For example, in Priest, claimant was still liable to recover the money claimed, relying on the principle of resulting trust. Therefore, piercing the corporate veil can only be utilized in exceptional circumstances where evasion principle applies as described by Lord Sumption. So here we explained the relevant law, but we said that in what kind of circumstances, what are the exceptional circumstances that Lord Sumption recognized this principle can be relied upon. Then we talk about the judgment of Lady Hill in Priest, stated that lifting the veil must be kept as a fallback position if one cannot find a different remedy. This was due to the fact that everyone who suffered unconscionable, unfair conduct from the companies should have a remedy when there are no alternative remedies to rely on. So this is like a last resort. So we provided a good overview of the relevant law, and now we have to analyze further. Therefore, the primary step is to find an alternative remedy. This is already analysis. We're just trying to demonstrate to the examiner that we understand what is the law and what is the process. If for whatever reason this is not possible, the claimant could try to argue that the evasion principle should be used and to persuade the court that the case is one of the exceptional cases where Lord Sumption's evasion and concealment principles apply. Lastly, the claimant could rely on Lady Hill's safety net if the above could not be argued successfully. So we have analyzed the law and the judgments of Lord Sumption and Lady Hill in simple terms and explained how the cases in piercing the corporate veil will be dealt for after this case. Overall, it can be stated that the case of Petrotto, judges were reluctant to pierce the corporate veil unless there was no alternative remedy. And there were strong arguments presented why the corporate vehicle can be disregarded in case of fraudulent activities detected. On the other hand, as argued in Adams, which is also a case about piercing the corporate veil, potential grounds for bringing the claim was quite wider than it is now. The judgment in Priest has summarized and clarified the legal basis in which the doctrine can be relied upon. So we have showed that before this case, then the scope of application of this principle was a lot wider, whereas in this case, Lord Sumption and Lazy Hill made it very, very narrow. Lord Sumption provided remarkable analysis of case law and compared it with his concealment evasion principles, which must be valuable guidance for future cases in this area. As a result of this case, the application of this doctrine has been narrowed significantly and shall only be relied on to deter the unconscionable conduct when there are no alternative remedies. This is just an extract from our essay, and you will be able to read the full answer on the link here. You will receive the slides after the session as well as the recording of the session. The next topic we will discuss is company constitution. So when the company is incorporated, every company has to have its constitution. If we compare to how the countries work, every country has a constitution, and or something like that. UK may not have constitution per se, that's another issue, but every country has rules under which it operates. So it's the same for the company. It's also called articles of association. These are basically set of rules that company uses for its day-to-day management, that the rules under which company operates. Company may adopt model articles of association that is offered by the Companies House in the UK, or you can draft your own ones as well. Companies' articles of association are the principal element of its constitution. Section 17 in Companies Act 2006 is the relevant section for this. Every company must have articles of association, which form the rule book companies can adopt, and it defines duties and responsibilities of the members of the company. In simple terms, companies board is like its cabinet. The chair is like prime minister. Together, they are empowered to run the company and make decisions. Specified shareholders are the electorate, and in general meeting, they act like parliament. If every shareholder of the company has one vote, whenever there is an important decision to be made, they will vote for it, and the majority vote will decide. The constitution can be altered, in other words, changed. You can read our notes on this topic here. The main section you have to know about altering the constitution is section 21. You may get a problem question on this or an essay question, so you must be prepared for both types of questions. It would be great if you have a look at our model questions and try to answer it yourself. Then you can have a look at our answer and compare it to your answer. Also, it would be amazing if you have a look at your past exam papers and practice answering every single question from there on these topics. After that, you could send your answers to your professor to get some feedback, or you could have a tutorial with us, a one-to-one tutorial, where we will review your practice answer and help you improve your legal writing skills. Section 21, company may be special resolution to alter the constitution. Special resolution basically means that company needs more than majority. Company needs 75% of the votes in order to alter the constitution. That's a general rule. However, if your constitution says that you only need 50%, 51% of the votes to alter the constitution, that can also happen. So the general rule is that you need 75% of the votes to alter the constitution, but you can change the general rule if you want to. Directors alone cannot alter the constitution. Once the alteration has been made, it has to be registered with the Companies House and it becomes part of the constitution. Whenever a company amends its articles, it must send to Companies House a copy of the articles. And if you don't comply with these rules, it can be a criminal offense. Entrenchment. This is a very important principle that you need to know about company's constitution. This basically means that you can change the general rule. The general rule is that for ordinary resolution, for ordinary matters, to decide ordinary matters, 51% of the votes will suffice. To decide extremely important matters, such as altering the constitution, 75% of the votes is necessary. That's why it's called special resolution. However, you can change those rules, and you can make some matters subject to 100% of the votes only, or some matters subject to that would otherwise be special resolution, subject to ordinary resolution type of voting. So you can change how do you want your decisions to be made, what percentage of the shareholders should be voting on the decisions. Directors' duties is also another topic that will most likely going to come up on your exam. It's very important that you know these duties. Section 171, from 171 to 177 of Companies Act 2006. But directors have a duty to act bona fide in the interest of the company, duty to act for a proper purpose, promote success of the company, exercise independent judgment, avoid conflict of interest, not to accept benefit from third parties. In other words, if you're a director, you cannot accept bribes. Duty to declare interest in proposed transaction with the company, and duty to exercise reasonable care, skill, and diligence. If a director breaks any of these rules, shareholders can bring an action for breach of fiduciary duties. Bringing an action against a director is usually comes up as a problem question on exams, and it would be great if you practice answering a problem question on this matter. Do directors owe duties to shareholders, employees, or creditors? The general principle is that directors do not owe duties to these people. They owe duties to the company. They are director of the company, manager of the company. They owe duties to the company, not to individual shareholders. This goes back to the principle of separate corporate personality. Company is a separate person. If company employs a director, that director owes duties to the company, not to the shareholders, because shareholders are not the company. The company is a separate person. However, there are exceptions, like in this case, Percival versus Wright. Directors only owe the duty to the company, not directly to the shareholders. Reiteration of Salmon's case. There are exceptions, like Priest versus Woolley. The director owed duties to the shareholders concerned because directors had undertaken to sell the shares of the shareholders. By doing this, they have put themselves in agency relationships with the shareholders and were liable to shareholders. So it's something similar to what happened in the case of piercing the corporate veil. The general rule, reiteration of Salomon's case, is that directors owe duty to the company, not to the shareholders. But if the court sees that directors did something unconscionable, something fraudulent, then they will be prepared to ignore this general rule and go a step further and say that the director can be in agency relationship in order to hold them liable for the unconscionable conduct that they committed. What is a fiduciary duty? The word fiduciary refers to trust and confidence. So basically, when shareholders appoint directors, that means that they trust them. They are in a position of trust and confidence, and they cannot abuse that trust and confidence. Equity protects by imposing on the fiduciary duty of loyalty. case of Bristol and West Building is a very important case that you should read after this session. We have a very good summary of this case. And yeah, it explains very well how fiduciary duties work. In the case of Regal, Hastings and Gulliver, Lord Porter said directors no doubt are not trustees, but they occupy a fiduciary position towards the company whose board they form. If they abuse that position, they will be held liable for it. Finally, insolvency topic is very important. Very often comes up as a problem question, so make sure that you practice answering a problem question on this topic. We have a model answer at this link. This is not a coursework though. It's an answer, a practice answer that you would be expected to write if you only have an exam and you only have like an hour to draft an answer. So it's a brief answer on this topic, but it will be very, very important, very good practice if you read it and understand how you would be expected to answer a problem question on this topic. What is insolvency? The main reason for a company to go insolvent is because it's unable to pay debts. So if someone has a company and it has a lot of debts that they cannot pay and the business is not going well, the obvious solution would be insolvency, which means that you will, whatever money is left in the company has to be divided between the creditors of the company, and the business ceases to exist. Creditors' voluntary liquidation. This is the result of is that company ceases to exist. This means that all the company's affairs must be resolved, such as removing the company from all its legal relationships. Its contracts must be completed, transferred, or otherwise brought to an end. It must stop its business. Liabilities must be met. Legal proceedings to which company is a party must be determined, and any property remaining must be distributed. Very important to know about this topic is what is fraudulent and wrongful trading, and know the case law around these topics. So if the business is going wrong and if there is no way to pay the debts, yes, the company goes into insolvency. However, sometimes directors may be held liable for it in case where the court sees that the director acted unconscionably, acted fraudulently, wrongfully. For example, when you're a director, you have certain duties, right? And if you see that the company is doing very badly and you keep making expenses that makes the company even worsen its financial situation, it can be argued that you're in wrongful trading. So that's what the kind of circumstances that will come under this heading, fraudulent and wrongful trading. There were cases where the directors saw that the company was probably going to go into liquidation in a few months' time, but they kept going on business trips, luxury business trips, and incurring many expenses that was not necessary at all. And after all, they were just trying to spend the remaining money and not give it to creditors. So if you're a director and then you try to spend all the money before going to liquidation, that can be argued to be a fraudulent or wrongful trading. And in this kind of scenario, if the court thinks that the director was involved in fraudulent or wrongful trading, the director may be personally liable, despite of the corporate personal, the Salomon case and the separate corporate personality of the company. The relevant case law is section 213 and 214 of the Insolvency Act, and it would be very helpful if you have a look at our model essay as well as these articles and our notes on this topic, so that you understand these issues very well. To sum up, You need to firstly analyze your exam requirements and create a correct study plan. Correct study plan should be adapted to what your exam requires. If it's a coursework, if it's an exam, then how many questions are you required to answer? How much time you have for each question, and make sure that you know every single detail and your study plan is adapted to the specific examination that your university is giving you. You should do the selective studying. You shouldn't try to learn every single case and every single topic that you have covered on the course, but by observing the past exam papers and by observing our model answers, you should be able to identify more or less what kind of questions you'll be getting on the exam and prepare the topics that suits the most likely the kind of questions that you should be getting on your exam. Thirdly, you need to practice answering problem and essay questions. So one thing is to know the theory, one thing is to read our notes and read our case summaries and understand the law around it, but it's absolutely different level if you practice answering problem and essay questions, because you should be able to not only know the law, but you should be able to apply the law you know to the facts of the case or to the essay question and make arguments. Making arguments is the hardest part. It requires a lot of time and practice. It's not something you can learn in 1 or 2 days. It requires a lot of practice. So it's highly recommended that you start as soon as possible. You start drafting answers to problem and essay questions. You could get tutorials with us. That would be great practice. And you could also send your practice answers to your professor to get some feedback. So grading is subjective, although some universal set of rules apply. It would be great in any ways to get some feedback from your professor by sending your practice answers to him or her, and then try to follow the guidelines. How can we help? On our platform, we have top students and graduates who create the content, and we also tutor students, and we give this this content created by top students and graduates to the rest of the students so that they have the right materials in front of them to effectively prepare for their assessments. We have simple notes, so instead of reading 100 or 200 pages in your very complicated, huge legal textbooks, you can be reading our simple notes, condensed and simplified in 10 pages or even less. You can be reading our model answers to the problem and essay questions that you will most likely going to get on your exam. You can be watching our tutorial videos, practicing with our quizzes and flashcards, and joining our study groups to interact with the community of our community of law students. If the resources we provide for you is not enough, we have an additional service, tutoring services, which means that you can book 1 hour with myself or my colleagues, and you can discuss any matter that you need help with. It can be upcoming exams you need help to prepare, or it can be the questions that you're practicing with and you need to some feedback on your practice answers, anything that you need help with. We have already helped thousands of law students to get high grades, and you can see the reviews here. 90% of our regular users get a first class. The key to getting a high grade is to study regularly. That's why the percentage of getting first class is so high with students who use our platform and our services regularly. We would love you to be our next student to get high grades. Please join Simple Studying and join our study groups at this link. Thank you very much for attending this session.